Welcome to Gloves Off, hosted by award-winning trial and personal injury attorney Venn Johnson, founder of Venn Johnson Law. In each episode, Venn goes toe-to-toe with guests, hashing out legal matters around the most talked about news stories and issues. We don't pull any punches, so some language and topics may not be suitable for younger listeners.
Welcome, fighters. Episode 28. Podcast is called, what's it called? We haven't done it for a while, JC. Remember?
Gloves Off.
Oh, Gloves Off. Jesus Christ. Hey, everybody. Today, I got Jason Carr and Steve Fishman. We'll talk to them real quick. But we're going to be talking about criminal law versus civil law. Are they the same? What do people think about that? And there's going to be a lot of fun with Fish because, of course, he knows one or two things about criminal law. He thinks he knows one or two about civil law, but we're not even going there, Fish.
I've never claimed to know anything about civil law.
Okay, that's a false lie. All right, Jason Carr, how are you?
I am well, my friend. How are you?
Excellent. Tell everybody about the Jason Carr Drive Show live on Facebook every day.
Don't sell yourself short. Jason Carr Drive, presented by title and presenting sponsor Venn Johnson Law, 855 Venn Fights. It's going gangbusters. More viewers all the time. Really taking off. Thank you, Venn, for providing the basis that got us going, up and running.
I told you about the two people that stopped me on the street in the last week. They say, thanks for sponsoring Jason. I go, shit, did I enter Alcoholics Anonymous and I didn't know? And am I so far along the path of that I'm now a sponsor? Fish laughs because, no, I've seen you at the bar in the
said
last.
Jason who?
I did say Jason. No, not to them. Because I wanted to act like, oh, you're so welcome. And I went, who are they talking? And I was, oh, it's Jason Carr. No question about it.
There you have it. Yeah, every day at 9 a.m., every weekday at 9 a.m., and Monday through Thursday at 9 p.m. Plus, I've started going out and doing these live on locations. I call them field trips.
Oh my God! Like at the Coney Island in Waterford, or where
the potato chip factory, right? Downey's. I've been all over the place, and the demand for those it's through the roof and growing all the time. So look forward to more of those in the field. So anyway, this whole idea of criminal law versus civil law. I am here. I want everybody to know that in the movie Twister, which pretty much everybody has seen, Jamie Gertz plays...
Except for me.
Yeah, that was after Purple Rain.
It was 1996, Fish.
No, it was after Purple Rain. I haven't seen it. I haven't seen a movie since Purple Rain.
By the way, you think he's kidding.
I'm not kidding.
But he's not kidding.
I haven't seen a TV show since the last edition of MASH.
I knew you were going to say that.
I think it was 1984.
You didn't even watch After MASH. The other show.
Never saw another one.
I'm here. The Jamie Gertz character in Twister, if you will recall, she was like the innocent who doesn't know all of this crazy, storm chasing and all the technology.
With Helen Hunt and Bill
Paxton. And Philip Seymour Hoffman, among others.
That's right.
And so they're crazy chasing these tornadoes, and she's kind of along for the ride, is like, I don't know what the hell's going on. She was there as the audience surrogate. So I am here as the listener surrogate. I know very little compared to my present company about criminal law versus civil law, but I'm here to be your listener surrogate and be like, whoa, wait, Fish, what do you mean by that? Venn, what does that mean exactly? So that's my whole role here today, and I'm happy to play it.
We appreciate that. Well, Fish, yesterday, the literally national news, of course, Ethan Crumley, I'm not supposed to say his name, so I'm going to now call him the shooter, and I'm not being facetious. That's what the surviving families have literally asked the media to do, so I'm going to refer to him as the shooter. It was his criminal sentencing. So, Fish, explain what that was, please.
Well, it was simple. It was up to Judge Rowe to decide whether he was getting mandatory life like everybody else gets if they're an adult, or he was going to get something different. And I read in the newspaper, said he gave him mandatory life, which certainly doesn't surprise me given the gravity of the offense.
Right. And without the possibility of parole.
That's today.
Right.
What people have to understand is there's a lot of things that are the law today that change in 30 years. Almost all of the case law that benefits defendants having to do with search and seizure and things of that nature were decided by the Warren Court in the mid-'60s. My marriage, for instance, would have been illegal before the West Virginia case.
The West Virginia case.
And things can change.
Explain.
Well, my wife was black and I'm Jewish, so it was illegal. Loving versus Virginia back in 1959 or 63.
Ridiculous.
The Supreme Court found that you couldn't ban interracial marriage, which today everybody would go, you mean to tell me it was banned?
Right.
It's like the Miranda rights. Everybody's been hearing it their whole life.
Right.
But that was a Supreme Court case in 1965. Before that, the cops didn't have to tell you anything. My point being that the law can change over time. And the law has changed greatly with respect to young people. And that was one of the issues that Kwame had to decide.
On the Miller hearing.
The Miller hearing
is?
The Miller hearing says that anybody that's still a teenager, basically, I don't want to go into gory details of it, but there's the whole analysis, and it's backed up by psychological testimony and things of that nature, that someone's brain's not fully functional, blah, 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 blah. And then you have to decide whether the crime is so awful that regardless of all that stuff, because it's pretty much undisputed, the medical and psychological testimony is pretty much undisputed about the effect on the human brain when a kid is young.
Right.
But
because he was 15 when he did this.
Right. But
17 now.
And I happened to see, I was in the gym this morning, I happened to see the TV was on, and now he looks like a teenager. Before he looked like he was 12.
He did.
And now he looked like he's a big kid, and I'm looking at him, he's going to be there.
Put on considerable weight, I might add, for a guy.
Well, the food is terrific in the county jails.
Apparently.
And you get tons of exercise. You're playing basketball every day, right? No, you're sitting on your butt eating garbage, and a lot of guys gain weight when they're locked up.
Is that right?
I was listening, they were carrying the sentencing live, and I was listening to the rundown of all the concurrent charges and consecutive charges, and they were read very painstakingly aloud in court to get to the eventual overall umbrella conclusion of he will never be a free man. Why do they go through the concurrence and even right down to the gun charges and time served of 870 days or whatever? Why not just say, okay, you're going to spend the rest of your life behind bars and that's it?
Well, before you guys and before all of this social media stuff, that's exactly how it was. I've been doing this for 50 years. And for the first, I don't know when social media started, but that's exactly what happened. No complainants or families, nobody spoke. You brought the guy in, you got convicted of first-degree murder, your sentence is mandatory life with no parole. Thank you very much, bye.
The whole thing's done in like a minute.
Everything that's done, and again, I don't watch television, so I can't say by the TV, but all of this hoop-de-doo with this case is really based on the fact that this is a different society now. Everybody has to talk. Everybody has to get their
victims' rights statements like were given yesterday, for example.
Yeah, people getting up and talking. And why did they charge 8 million counts? Because it reads good and it sounds good to the media.
Well, and I would imagine it also gives the families some measure of satisfaction, some closure.
Except that if somebody's telling them that means anything, they're lying to them. Because the first-degree murder charges is all you need. If a guy's convicted of first-degree murder, he gets mandatory life. That's it. You don't need gun counts and all that other the stuff that you're talking about. They do it. I'm telling you why they do it. They're doing it because of the press and the media and everybody making noise all the time. How many people were what?
The other argument would be, Fish, and I'm obviously not a criminal law expert, but you've been in trial, you've won certain counts on behalf of your clients and then lost another count. So they're just trying to get multiple bites at an apple. So if they didn't convict him of first-degree murder, which of course he admitted to, but if they didn't, then they got 10 gun charges against
Right, but in this case, everybody knew what was going. This whole case was played out to the public and to the press.
Right.
And you would say, and a lot of people would say with good reason, because it's such an awful thing that happened.
Right.
But the answer to your question, all you had to do was be a lawyer in the 70s and the 80s and the 90s, and you'd have seen exactly what you just described.
Wow.
Bring the guy in, give him his mandatory life, off he went. Then he appeals, he doesn't appeal, he marinates there for 50 years or whatever.
Well, another interesting thing relative to the victims' rights comments and statements like we had yesterday, guys, in Oakland County that I was in that courtroom for the entire day, is like, for example, on the Larry Nassar Michigan State criminal case. Well, it wasn't Michigan State criminal, but Larry Nassar criminal case, and Judge Aquilina in Ingham County in Lansing allowed, over 100, I think, victims' rights statements. So it's kind of a new thing. Fish, are you like that? You don't like that?
You want candor, right? That's what we want.
No, I want you to bullshit like everybody else. This is Gloves Off podcast, baby.
I'm not bullshit. No, I can't stand it.
Right.
In fact,
I
stopped. I don't go to state court anymore for any number of reasons. I just do federal stuff. But when that started, I couldn't stand it. We already knew most of the time what was going to happen to the defendant. And when it first started, very few people came forward and talked. Very few people, at least in Detroit in Recorder's Court, because people kind of felt the way I felt. If something happened to a kin of mine, there's no way on earth I would talk to the press or say anything to the judge. Not in a million years, because I don't want to talk about the whole thing. And it's, whatever's going to happen is going to happen. So yeah, I couldn't stand it. And I can tell you, I saw more than one case where, not a case like this. And keep in mind, this case here is it's not unique anymore in this country, but it's a pretty unique thing to have this kind of killing of this many young people.
Right.
The normal homicide or the normal whatever the case is. I have been in court in the old days where judges were more like me. They were more in my age group and a little older. And the complainants, we call them, now everything's victims' rights, the complainant would come up and make a statement. And I remember one homicide in particular where the defendant was going to get X. There was an agreement, basically, he was going to get X.
I mean, in other words, jail time, prison sentence.
It was a homicide, it was a manslaughter case.
Jail, by the way, is county jail. Prison is the state.
No, this is prison. This is prison, obviously.
So prison is where they go, where our shooter
And because
will go.
of what the mother said about the victim, who was a street guy, the judge said, "Do you want me to consider what you're saying?" And she said, "Yeah, absolutely." And he gave him a year less.
I have a question. You mentioned just now, Ven, you said the state is the prison and you've got the county jail.
Right.
So the shooter hears the words, okay, you're spending the rest of your life in prison,
right.
and, gavel, off you go.
Right.
It's over. He gets led by the deputies, the bailiffs, out the door, the door shuts. And so how long does the shooter reside in the county clink, the lockup, before the Shawshank bus comes and scoops him up and takes him off to Jackson or Shawshank or wherever?
In state court, this is state court we're talking
Correct.
about, not federal court. In state court, they get him out of the county jails as quickly as they can because
of overcrowding.
A, yeah, and B, once they're sentenced, they don't want them around anymore. They want to just get rid of them. And so my guess, maybe it's a different case because it's different for so many reasons, but he was sentenced when? Yesterday? That was Friday?
Sir. Yes.
If he's not gone by next Friday, by this coming Friday, I'll be surprised.
Right.
As soon as a guy is sentenced, they one of our judges, back when we had regular court, real court, without TV and without all that stuff, Henry Heading used to say to guys, he'd say to the defendant, a guy was a smart ass or something, he'd look at him and he'd say, "Son," he was an older black guy from down south, he called everybody son. He'd say, "Son, the only thing that's going to beat you to Jackson Prison are the headlights on the bus." And of course, and keep in mind, the reason that court was so much better and that the whole thing was better.
Here we go. It's always better.
Oh, boy.
No, I'll tell you why.
Buckle up.
Come on, we need some music. Chelsea, find us music of Fiddler on the Roof or something.
It was better.
Fix it in post.
It was better because nobody was playing to anybody. There was no TV and no, forget the social, there was nobody there. So a judge didn't have to worry. These judges nowadays, they're afraid to say anything at all because it's all on television or it's all somewhere.
I like that. It's called transparency and hold them fucking accountable for the dumb shit that they say and do. If they do it. If they don't, they don't.
But that's why we have courts of appeals. We could always appeal people. But when Heading would say it, it got to be it was something that everybody in the county would know. They'd get judged. Oh man, when I go, he's going to tell me the headlights on the bus. It wasn't any big deal. Now everything's a big fucking deal. It's just the way it is.
Okay. Well, now that life sucks, let's move on to.
All right. First topic on the docket. I like how I use the word docket there. Burden of proof. Criminal versus civil.
Fishy, go.
Lead us off.
Well, that's fairly simple for those who are listening. It's not very complicated. You don't need law school to figure it out because jurors figure it out all the time. The burden of proof in
criminal law.
You want me to go criminal first?
Criminal. I'll do civil. You do criminal.
The burden of proof in a criminal case is proof beyond a reasonable doubt. What that means, if you want me to talk about what it means to a jury?
Sure.
Or are we just going to do it?
No, do it.
Superficially?
No.
What that means is, and this is a huge distinction from civil cases, what that means is jurors, if the lawyer does a good job, and if the judge does a good job in the terms of the instructions, jurors can believe the guy did it. They can think that he did it. They can even feel, I'm pretty sure that he did it. But if they're not convinced beyond a reasonable doubt, they have to find him not guilty. And the best not guilty verdicts I've received in all those years with all those homicide cases would be if I bumped into the jurors on the way to the car or something, and they say, Mr. Fishman, we really thought the guy did it, but you told us it had to be proof beyond a reasonable doubt, so we let him go. And that's how they would say it. We let him go. They
Basically,
wouldn't
what
say,
you're saying is, I can sleep tonight because I reached this decision based on this one
The law.
thing. The law. Burden
that's
of
it.
proof.
And that's what every time I would talk to young lawyers, and still when I go and speak at conferences, I always tell them, you got to make sure that jurors understand that what we're asking them to do is something that's completely different from ordinary life.
Do the logic.
Yeah. Here's a perfect example.
I love this.
There's three things in a criminal case that we don't have in civil cases. Number one, the defendant's presumed to be innocent. Number two, the government has to prove it beyond a reasonable doubt. Number three, you got to prove it. And then number three, you got to prove it beyond a reasonable doubt. When jurors are asked by a judge, well, can you presume Mr. Smith here innocent? They go, sure. And then I get up and I say, Mrs. Johnson, I heard you say you can presume innocent. Let me just give you an example. You and your husband are driving downtown on the John C. Lodge Expressway, and you see a police car with the lights flashing, and you see a guy with his hands, and I always put my hands on the box there, and he's being patted down. What's the first thing you think? And she goes,
guilty of something.
I wonder what he did. And then I turned to the rest of them. I said, let me ask you guys something. Same situation. Do you think any of you go, God, I wonder what he's presumed innocent of doing? And they all laugh.
That's so good.
And you've accomplished two things. You've got them to relax and loosen up. And I always memorize their names so I can go boom, boom, boom. You don't have to look at a sheet like you're doing. And the second thing is they start to recognize that this is counterintuitive. What we're asking jurors to do in a criminal case, not a civil case, because of the burden of proof, it's counterintuitive, and you got to explain to them what that means. They can't just assume because the guy's sitting here.
Well, you can't assume because that makes an ass out of you and me.
If you're in the Marine Corps, yeah, that's for sure.
And in Saginaw, Michigan, growing up in my house.
So that's the situation with respect to criminal law. So,
all right, what about civil? Ven Johnson, you have the floor, sir.
Civil law burden of proof is much lower. It's called beyond preponderance of the evidence. So what I do in my opening statement, explain to the jury, is if we think about the scales of justice, that if you don't put anything on either scale, they're supposed to be even. You start with a kind of a 50-50 split there. All I got to do at the end of my case is prove 51% or more. So if it's 51-49, I win. But as I always say, it's going to be a lot more than that, and it's going to be an overwhelming blah, blah, blah. But so it's much less than the criminal case. So, and then what is negligence? Negligence is simply the failure to do what an ordinary, careful, and prudent person would do or wouldn't do under the circumstances. You're going down the road, Jason, you're on your cell phone, which is now illegal, but you're on your cell phone and you run a stop sign, and then you hit my client, and I sue you. You break the law. You were negligent because an ordinary, careful person would not be on their phone and would have seen the stop sign and stopped. So it's a much lesser burden of proof than in the criminal case, and that's significant. It's better. And what's interesting, Fish is pointing out what the prosecution has to prove, whereas in a civil case, I'm kind of like
the burden of proof
a little bit like the prosecutor. I have the burden of proof. Does that make sense?
No, yes, it does. But let me ask you this: as a layperson,
right
now, in the criminal case, it's very cut and dried. It's the law or it's not the law. It's black and white. Whereas in your case, are there shades of gray?
Yes, we have a saying in the civil law: "Shades of gray get us all paid." What that means is, if a jury gets to make the call, in other words, if the case goes to the jury, then what it typically does is make both sides a little nervous because you never know what a jury's going to do. And then 98 to 99% of all civil cases then settle. Okay. But so uncertainty works in a weird way. The advantages to it is people normally settle the case instead of go to a jury verdict, usually.
Now, the only time that I ever sat on a jury, and it was for a full week, it was in Genesee County at the courthouse downtown. It was a civil lawsuit between a trash bag supplier, the vendor, and the customer, the client. And one sued the other, and then they countersued. And the whole thing was, what was supplied? Were the bags 8 microns thick, or were they 12 microns thick for the amount of money paid? And that went back and forth for a full week in court. And as a jury, we ended up with this kiss your sister like split decision. And both the plaintiff and the defendant's attorneys afterward were like, where did we go wrong? How did he fail? How did I fail? And we were just like, we couldn't really give them a straight answer. Does that happen a lot?
No, not a lot. Typically, in what I do, if I'm going to get a verdict, I have to have overwhelming evidence of like what I told you. In fact, we just had a case that thankfully settled this week. Very big case, wrongful death case. Dad going to pick up the kids from daycare, 5 o'clock in the afternoon, and a truck blew a stop sign when my client had no stop sign, and just not only obliterated the car, but separated his head and brain off of the top of his spine. So obviously dead and horrible. So, but that guy was either on the cell phone, or not only did he miss the red stop sign that he missed, that he should have seen, but there was a warning sign about the stop sign before that as well. So we had overwhelming evidence. So it wasn't going to be 51. In our opinion, it'd be 100-0. Okay. And once you do that, Jason, in civil law, now the jury then goes to damages and they start to assess how much to give and so forth and so on. Whereas in criminal law, Fish, they don't get to assess how much time someone goes to jail.
The funny thing is, there are jurisdictions, and I've never been in any. There are states where the jury has a say. I think there are even states where a jury gets the chance to actually sentence the guy.
Interesting.
And
I did not know that.
This is, I think, I mean, I don't want to be held to it, and this is many, many years ago we're talking about, too.
Was this before
This is
Purple
not
Rain?
admissible in court.
Was this before? Was it before Purple Rain?
It was probably before
Pre-1984,
Purple Rain.
yeah.
It was probably before. But you know, that is a very interesting thing, because there have been times where jurors give split decisions in criminal cases as well at times. Not so much because yours is a kind of a weird situation. Criminal cases, generally the jury, it's pretty simple. Boom, boom, boom. It's not going to be a twisted up thing like you sat for a week arguing over 8 inches or 12 inches or whatever it was. But jurors will do that. They'll come back with what they think is, and don't forget, they're not told. See, jurors in the state of Michigan are not told, or in federal court, they're not told what the penalty is.
Right.
So what
Which
we
is
try,
weird, because it's so opposite from what I do, where I get to tell the jury
what we
I
try to
want.
do is, if we get lucky, and I've had I don't know how many first degree murder cases where a guy makes a deal, there's a snitch, because there's always snitches, not always, but a lot of times there's snitches in criminal cases. The guy makes a deal and he's taking manslaughter and he's getting 10 to 15 because he made a deal, and that's part of what his agreement
And then
is
he
with the
testified
prosecutor.
against his buddy.
Now he's testifying, and I can get up and say, so, you know, Mr. Jackson, you pled guilty to manslaughter, and you got a deal, you're going to get 5 to 15. True? Yeah. Well, you weren't in that situation when it started, were you? The guy goes, no. In fact, you were looking at mandatory life, and I'll say it loud.
Mandatory life.
You were looking at the same charge he has, and that carried mandatory life. And just in case they don't know that means you never get out, right? And the guy's going to say right.
Right. That's
Then
good.
it's admissible. That's the only time that they'll ever know
Interesting.
what the penalty is.
As a criminal attorney, I talked about how the attorneys in this civil case were able, both sides were able to come to us in the jury box and say, you know, what do we do right? Where
No,
do
in
we
the
go
jury
wrong?
room you're talking about, not in the box.
So I recall it being in the courtroom, but this has been 25 years
Okay.
ago. Do the jurors or do the attorneys in a criminal case, after the guy's let out by the bailiffs and he's gone, he's off to life in prison,
Or if he's Fish's
No, he's
client, he's
going home.
innocent.
What do you mean?
He's
We're
going
going
home.
home.
or I mean, in any case, do in a criminal case, do the two attorneys have the opportunity afterward to talk to the jurors and say, where did we go right? Where did we go wrong? How did, you know, arriving at your verdict? Is that a possibility, or is that? I'm asking as a layperson who doesn't know.
So here's the answer. The answer is a simple one. It doesn't matter if it's criminal or civil. The lawyers, if they want, and I'm the criminal lawyer. Attorneys are fancy people like Ben. I'm just a lawyer, just a poor boy from Mumford High School.
So he's a counselor and an esquire.
Yeah, exactly.
You're just a simple Atticus Finch.
I'm just a simple. I'm just a poor boy from Mumford
There
High.
we go. Hey, hold on. Let's see how many minutes it took. 28 minutes and 26 seconds, ladies and
So
gentlemen.
the
First
answer,
Mumford reference.
The answer is that the lawyers have the right, if they want to. I'll get to that if you want to hear. They have the right to ask the jurors to talk to them. The jurors have the absolute right to tell the lawyers to go fuck themselves. I don't want to talk to you.
I figured as much.
And I personally I've never been a big believer in talking to jurors. The times that I tell you I bump it, in recorder's court, you'd be waiting for the elevator. The last jury trial I tried in there, they let the guy go, and I'm waiting for the elevator, and I have a long leather coat that one of the fellas gave me.
From Purple Rain.
It looks a little bit like Purple Rain, but no, it's newer than that. It's a pretty good coat. But the jurors came out and they told me, Mr. Fishman, seriously, we really need to know where you got about that coat. That's all. That's what they were talking about back there, about my coat. The evidence was clean.
Because they've already, in other words, they were so
They found him not
convinced
guilty.
on the evidence, they
Yeah.
found him not guilty.
No, but the point
So
I'm
that's what
saying
they
is
wanted to know.
the times I've had conversations with jurors inside the jury room, the times I've ever asked to talk to them are very, very, and I've probably had, I don't know, 200 jury trials at least.
Yeah.
I just don't do it because they don't tell you the truth either. If they acquitted,
That's-
then that's one thing. I don't need it. If they convicted, you're going to say, what did we do? They're going to lie.
Right.
They're going to say, oh, you were great, or it's a waste of time.
In civil law, Jason, it is like everyone thinks that I'm such a freak because I don't normally do it. I used to do it early on in my career, but I agree with Fish. They tell you everything in their verdict. If they find in my favor and then give my client $200, they didn't believe my client's damages and or hated me or both.
Right.
So I don't
You don't need to flog that.
I
Right.
don't know. I'm
Right.
good on
We
it.
don't need to hear that over again.
Last year in Oakland County, I got a pretty nice verdict. We ultimately had a judgment of over $8 million, and the defendant, of course, never offered a dime and thought it was. Remember that whole case, and I sent my jury consultant to go back because the defense lawyer was adamant, I need to go back there, Judge, can I go back? By the way, and what the judge typically does nowadays in the civil world is he'll talk to the jury and say, do you want to? And if they say no, then they can just go. But most jurors will say yes. So the defense lawyer went back, and then my jury consultant went back, and then jury consultant comes back into the courtroom and says, hey, they want to talk to you real quick. So I go in there, number one question is, where do you get your suits?
Yeah,
right.
Seriously.
So, and some people would be bothered by that and say, "That's all. Is that why you won?" No, it's not why I won.
It's fun.
But the evidence, the case they'd already dealt with, and they gave us $8 million. Yeah, I think they liked the case and they believed us, right? But so they just wanted to find out.
I can give you a similar story.
Aaron and Mo, John, thanks for my suits at CavalryandCompany.com.
Cha-ching. That's what you call a plug right there. A plug.
I can give you a similar one. I represented Donald Curry, was a welterweight champion of the
Yes,
world.
he
They
was.
charged him in a big drug case, and I represented him in federal court, and he's found not guilty. And I didn't go back to talk, and I was leaving, they had my coat on, and 2 or 3 of the female jurors come out. Oh, Mr. Fishman, we got a question for you. And I thought they're going to ask me, was Donald Curry really a great fighter? Blah, blah. They said, what kind of cologne do you wear?
It is.
And what is the answer?
No, and the answer is it smells good. I'm not going to lie. Remember,
yeah.
Shannon used to tell you that every time you're around.
Right. No, and that's what they
I'm waiting for the plug. What is it called? Paco Rabanne? Pierre
No, what
Cardin?
do I
He doesn't even remember. Dude, he's probably got like a black bag now. And like,
Aquavelva.
No,
Skin bracer?
no. What do I have?
oh my God, Fish.
Paul Sebastian. That's what it is. Paul
Oh
Sebastian.
wow, I didn't even know they. Still
But that's
made
what they told me. They said, everybody was wondering, what kind of cologne do you? This is what you're thinking about back there?
So real quick, so Fish and the judge does the sentencing, but in civil cases, I ask for money. The defense then says that's a ridiculous amount. Don't give it to him, and then the jury ultimately decides. So in a weird way, compared to sentencing, we get to talk about the sentencing. So that is a huge difference as well.
Huge difference. Yeah, I cannot argue to a jury. No defense lawyer or prosecutor, we cannot get up and argue. If you don't let this guy go, he's getting mandatory life or he's getting 15. You cannot mention anything about sentencing in a criminal case. Civil case, that's the whole case. Right. Well, it's the second part of the case.
Well, on that note, is there a benefit or what's the cost benefit of either going first or going last presenting?
In a criminal case?
Yes.
The biggest difference between a criminal case and a civil case, when it's something like me and Ben, I'm the defense all the time, and he's the plaintiff all the time. It's the difference. You can't even really discuss how different that is.
Let me interrupt you. As a layperson, what is it, a coin flip? How is it decided who goes first in a court of law in a criminal proceeding, the prosecution or the defense?
It's really simple. The prosecution goes first. Why? Because the prosecution has the burden of proof. They go first in a civil case because they have the burden of proof too. It's a smaller burden, but it's still the burden of proof. So the government goes first, and I react. Everything that I do is reactive.
Defensive.
I wouldn't call it defensive. It's reactive. I'm reacting to what it is that they're doing. He has to be proactive for 2 reasons. Number one, he's got to convince them on the 51 to 49, but most importantly, he's got to convince them, I want X amount of money too, because I don't want $200 along with, they did it, but it's only $200.
Right.
It's a completely different mindset.
It's funny because until Fishman represented me in the criminal case that we've done podcasts on, y'all can watch and actually not watch those, or you can watch these, but we recorded those, and Steve was on about my criminal case with Jeffrey Feiger as well, and Jerry Spence and all the blah, blah, blah. The fact of the matter is I didn't know him till then, And we really didn't have a criminal guy. I didn't. He didn't really have a civil guy much in their life where they would hang out and talk and so forth. And I think, Fishy, I think this is one of the biggest things that you and I talk about is like going first is such an advantage for me because primacy, recency. So if I'm showing you all the ways that truck driver was negligent, JC, you're going to think, without even hearing Fishman, if he was the defense lawyer in the civil case, you haven't heard him yet. And for over a week, all I talk about is all the shit that guy did wrong. Right? And then Fish gets up there and does it, and he does it within a day or two. And then guess what I get? Because I have the burden of proof, I go last. I go first and last. It's called rebuttal if I exercise that. I don't normally, but that's different than closing argument.
How long does going first last? Is that up to the judge?
No.
Is there parameters on that?
The judge could say, John, you're taking too long, blah, blah, blah.
Every judge can restrict you, but most judges, if it's lawyers like us, where they know that we kind of know what we're doing, we've been doing it a long time, the odds of the judges, I've never had a federal judge, never had a state court judge say to me, you only have X. Yeah. Probably because I talk so fast. And the couple of times it might have come up, I'd always joke with it, oh, that's fine, you're going to give us time limits? I'll get a lot more words in than he will.
Right.
Because he can't talk as fast as me.
Sadly, it is common. I won't say over 50%, but it does happen a lot, and luckily it doesn't happen a whole lot to me, but I have had it. It is a pain in the ass and it sucks, but it hurts.
Being limited.
Yes, it would hurt the plaintiff to be limited in what I do.
What is the longest, Fish, that you've ever had opening? Now is going first the same as opening statements? Or
no, here.
Let Fish, yeah, go.
So what Ben's saying, as the plaintiff, he gets to make an opening statement, and he tries, because I've come and listened a couple of times, he's trying to win his case in opening statement. It's exactly what the government does. And that's exactly what you should do, whether it's a civil case or a criminal case, because this is something that I always speak to the young lawyers when I go to these conferences. If you don't give a great opening statement in a criminal case, because you're going right after the prosecutor gets done. He gets done, sits down. Now I got to get up. If I get up there and, well, ladies and gentlemen of the jury, he's presumed to be innocent. The jurors will start. The next thing you know, they'll fold their arms like this, and we all know once they fold their arms like this, it means, would you just shut the fuck up so we can convict your guy and go home? You better be ready to contradict and tell them why it is that what you just heard is horseshit.
Let me ask you on that note.
Like my cousin Vinny.
12. You got 12 people. How many of those 12, by the end of going first, opening statement, that first rock'em sock'em home run out of the park, if you're, good, how many of those 12 have made up their minds by the end of that first opening statement?
It's impossible for us to be able to say how many people, whatever it is. But I can tell you this, and this is exactly what I tell every lawyer I've ever talked to. If you don't get up and make a very powerful opening statement as a criminal lawyer after the government, particularly in federal court, because they're prepared. And now they have cartoons, which they call PowerPoints. Cartoons. I call them cartoons because I don't use them. But if you're not ready to get up and say why that's horseshit, it'll be 10 out of 12, 8 out of 12, 12 out of 12. Right. But what you have to do, the key to any case, either side, but particularly criminal defense.
You say either side, civil or criminal.
Either side, plaintiff or criminal defendant.
Right.
What I have to do is I've got to get their attention, and I got to get it quick. So you don't stand up like a lot of young lawyers do and start reciting the law, which the judge gave him about the presumption of innocence. You got to get up and say, look, let me tell you I'm going to show you. The evidence will show you. I can usually focus on one or two things because the government always overplays their hand. He said so-and-so is going to say such and such. Wait till you hear it. Wait till you hear everything else, and then you can tell the jurors say, oh.
They sit up.
And they're listening. And that's all. What you want them to do is you want them to say there's more to it than what we just heard. Because if you don't make a powerful opening statement, same thing if the defense lawyer in his case doesn't make because he's going to have charts and all this shit. And if you don't make a powerful
cartoons,
and then
he's going to bring 11 people. That's nobody uses that phrase. In the 60s, that's how we talk for a big number. He's going to bring a bunch of experts in, and they're going to ba-dum. And if you don't get that jury prepared for it in your opening statement when you're the defendant, you're toast. I'm telling you, there's nothing more important than opening statement.
I agree. I've always said, and JC, we're going to wrap this up because this is too good, and we're going to do exactly what you said we should do. We're going to do 2 segments in this because it's so great. But in a plaintiff, especially a personal injury, but I would say civil arena, when you go first, you want to come out of the box big and show all the things that the defendant did wrong. And what am I trying to do? Yes, I'm trying to get the jury persuaded as much as I can. We have the benefit of doing mock trials, and Fish has watched a couple of the ones that we have done. So in a mock trial, which is not a normal trial, it's a fake trial, but we're kind of testing it to see if we're on the right wavelength and so forth. When we do mock trials, not a real trial, we get to give the jury a questionnaire, and to answer your question, overwhelming majority are convinced when you have them write stuff down. Are you convinced? Are you not? And then what's really interesting, then when the defense lawyer goes and gives their opening, assuming they did a good job, like Fish just told you, they have to come out and say, Johnson says this, and it's all bullshit. They swing back. And what happens is you watch the jury swings.
Pendulum.
Yes, it's fascinating. But I agree with Fish from what we do, especially when I get to go first, come out of the box, talk about how great this evidence is and how badly injured my client is. We have a really good shot at winning.
I think that's a good analogy to call it a pendulum, because that is exactly what you're trying to do in a criminal case, because that pendulum's way over here when you stand up. And if you don't get their attention quickly, then it kind of stays there.
Right.
And you start. That's why you have to get up there. Boom, boom, boom. That's why when people write out their opening statements, it's one thing for the plaintiff or the prosecutor, because they're not going after anybody else. But a lot of the criminal defense lawyers, they write out what they're going to say. And I always tell them, how can you possibly write out everything you're going to say? You haven't heard him yet.
Right.
And when she, let's say the prosecutor, she gets up and she says something, and it happens all the time if you're paying attention.
Every case.
If you're paying attention, something that the prosecutor says is something she shouldn't have said.
Right.
And it's going to, and then you know, ladies and gentlemen of the jury, I'm sitting here the same as you, and I heard her, I could have sworn I heard her say, and then you say, wait till you see what the evidence shows. And then you go. And then the jurors, the pendulum, at least you can get it to hear. I just want it to hear.
And in civil cases, what the defense lawyer will do is exactly what Fish says. Johnson said, blah, blah, blah. Well, I don't know where he got that. He knows that's not the evidence. The evidence is this. And it's all of a sudden, oh, well, maybe Johnson misled us, right? So he or she is planting those seeds. And by going second, instead of having to reinvent the wheel and coming up with a brand new story, you poke 2-3 really good holes in what some other person just said. And all of a sudden it's like, oh, shit, well, there are two versions to this story. I need not to jump to conclusions.
So if you're
and listen.
defending, you want then, after he's had the opening statement, you've come back with this poking holes. You want him kind of.
No, he's done.
I'm done.
We're done.
Now we go to the evidence.
The evidence.
So the evidence starts.
Yeah, and the evidence starts. And what I try to do, and I think what you're really trying to do is to identify what exactly it is that the government said that's horseshit. And particularly if it's when they have a snitch or something, they'll say, and you're going to hear from some. Well, do we have to be done in 2 seconds?
Yeah, because Riley's calling.
We can set the stage for part 2.
Here's a perfect example. A case I tried in federal court representing cops, and a lot of the witnesses were dope dealers and just street guys. And they were claiming the cops stole the drugs and all this kind of stuff. And the prosecutor didn't mean to do it. Well, he knew he was doing it, but he didn't realize what he was doing, and said that these dope dealers had come forward and complained about these cops, but who would believe them? And then he went, and so we got this and we got this, but he said the phrase, who would believe them? So I never write anything down. So I wrote down who would believe them. And I got up after I told him I had a flip phone and I didn't have cartoons. I said, and you know, but
and he was writing with a piece of coal or chalk on a chalkboard on his desk.
And so I told him, I said, this doesn't ordinarily happen. I said, but I have to tell you, I agreed 100% with Mr. Light. When he said, who would believe them? I can tell you who won't believe him. You guys. Boom. And then we went off, and you could see the look on their face.
So use that theme, right?
And that theme was...
Now you've got
I guarantee you he said who believed them for the next
That was the theme
week.
At the end, in closing argument. I reminded them. Remember when they said who would believe? Now you've heard these assholes. Well, I didn't say assholes, but I kind of did, you know. And they acquitted on 10 out of 11 counts.
Wow.
Next on the docket, public opinion, perception, the media's role in that, TV, cameras, what's written in the papers. Again, if you're just tuning in, this is civil versus criminal law and how those two differ on these points. So, Fish, or you want to lead off?
Yep.
Ven wants to go first. Okay, so you know,
No, he should. He believes it. He believes it.
public opinion, the media, the perception, the whole circus.
One of the things when I pick our jury, we call it voir dire or voir dire or Fish. You probably say it fancy. I say
No, voir dire.
voir dire. is when I'm asking potential jurors questions where I can actually question each and every one of them to see if they're a good fit for this case. I'm talking about all of those very things. And one of the things that will often come up is, I advertise. I've done television, I've done billboards, I do print ads.
Social media live streaming.
You got it. Like Jason Carr Show. But in any event, and I talk about that because a lot of people, I hate those billboards. Yeah, I hate those ads. And I hate guys like you that do this stuff. And so I need to have an understanding of how deeply rooted that hate is. Is that something that they could just say, yeah, that's what you guys do and that's how you get cases? Or is it, no, I just hate you guys. So I definitely go there, and I have to really spend some time and explain some things. So one of the things that we also did is we talk about, speaking of public opinion, I bring up the McDonald's case where the elderly lady
With the coffee?
because everyone was just so appalled. And so I always talk about, well, it's interesting. Now, can we all agree that there's way too many lawsuits? Oh, way too many lawsuits. Can we all agree that there's way too many multi-million-dollar verdicts? Oh, way too many. Okay, now let's talk about this. How many of you here have filed your own lawsuit? No one. Okay, so in terms of all those lawsuits, at least you all have it. Great. How many of you here, if you haven't filed a lawsuit, have had a multi-million-dollar verdict? Oh, none of you have. Wow, that's interesting. Okay. Well, let's talk about the McDonald's, right? A horrible case, blah, blah, blah. Were you in the courtroom? No. Did you go back and read the court transcripts? No. Did you know that in that particular case that the McDonald's had been sued 4 previous times because the county Department of Water person or whoever said that they were having their water at 150 degrees burning people? And they were not supposed to, by way of law, it was in Albuquerque, New Mexico, they were not supposed to be over 120. Did you know that? No. Well, how many people do you think it's okay to burn where they have to go and get surgeries and so forth before they get away with that? Or that's, so I would do this and say, so in other words, all this shit that you hear, you have no idea about any case until you're in it. And by the way, you talk about too many frivolous lawsuits. How many times have you read in the media too many frivolous made up defenses by corporations or people sitting in that seat? None. So yeah, I take that head on, and I have to. Why? Because they think I'm an ambulance chaser and I'm going to lie, cheat, and steal, and that my client is a faker and a liar, even if they're dead. And I got to get them over that hurdle.
Here's what Fish, of course, weigh in. What I remember about that particular case was that you already had some people in society or some measurable quadrant of people that were like, hell yeah, McDonald's coffee is blazing hot when you get it through the dryer. You can't even touch it. You got to let it cool in your cup holder or in your tray.
She didn't have a cup holder. She put it between her legs. She was an 82-year-old woman and had 4 surgeries on her labia, ladies and gentlemen. Labia. So she had extensive plastic surgery of her vagina.
But in that particular case, I think that there was already a perception in the public mind that McDonald's coffee was blazing hot and they could relate.
Okay.
Maybe I'm wrong. Maybe that was just me.
Okay, so here's what Ben just said. There's a few things about this, about the whole issue of media, and I'm going to try to do it fairly quickly. What he just said, though, is exactly right, that he has to be aware of the perception somewhere, particularly when you ask about the billboards or whatever. There's a perception amongst some people, not all, but some people that you're an ambulance chaser, blah, 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 blah. All your cases are bullshit. It's kind of the same thing for criminal lawyers. It's not ambulance chasing, it's not billboards. It's just that, yeah, criminal lawyers, everybody did it. They just come in and lie to us and make the shit up. And everything they tell us is horse manure, and they base it on what they watch on TV.
Right.
So back to when I was talking earlier about, I want to try to talk with them to get them to understand what the function is of the lawyer. I want them to trust me, not because they're going to say, oh, I really like Fishman, therefore not guilty, but I trust him that he's not one of those, which is what Ben's trying to do. He's not just an ambulance chaser. I'm not just some guy who represents anybody and come up with some bullshit to defend him every time. The business about the media, the effect of the media nowadays, as opposed to in my day, when I tried 3 cases on Court TV, 3 not guilties, all police officers that were charged with homicide, murder, manslaughter, and they had one little camera in the top. It was completely unobtrusive. There were a couple people from the local TVs, but the local TV stations, they don't give a shit about every day. They just wait for the verdict or something. The defendant's going to testify or whatever it was. Now, I think it's much more difficult for people, and forget the case, the Oxford case. The regular criminal case, if it gets in the press, it's a lot different than it used to be because the press is everywhere, like we've been talking. It's on the social media, they're on the TV, they're in whoever way they go. So you have to make sure in your voir dire, if you're given voir dire, and if you're not given it, you got to press the judge to do it, and then you better do it in opening statement. But you have to make sure that people are not going to do something just because they read it in the newspaper.
Right.
And I can tell you,
Right.
when I tried Weekly's case, there were press people there. This was on national television. No, this was on
Another cop was accused of murder.
Accused of murder. He was acquitted. But
Was that Malice Green? Was that Malice Green?
No. That was the little girl, the one where father got.
Jones.
Yes. I shit on the media in the voir dire. Finally, Cynthia Hathaway, she lets you voir dire, thank God. And she found Mr. Fishman.
This is the judge.
Yeah,
Right.
well, she's retired now, but she did a great job in the case. She let me voir dire, and I basically got the jurors to agree that there's not one thing they read in the newspaper, not even the weather, or that they see on television that they believe, because all of you are full of shit. And they all were nodding their heads just like that. And it was important to do that.
Why'd you
because
say you? I'm not in that circumstance.
well, you used to work there, but in any event, my point
Killed
being,
by former association.
my point being that you have to make sure, if you can get away with it like I got, to the extent that I got, where they were all agreeing, basically, that's the best. But at least you have to get them to acknowledge that there's the distinct possibility that what you read in the paper, what you see on TV, is not the truth, and that they got to base it. Ben hit it right on his head when he said that about you don't know what the real facts of the case were. You got to get them to the point where whatever it is that they think when they sit down, everybody comes with some preconceptions, but you got to get them to say to you, you know, I'm going to listen to this case, to these facts, to the law that the judge gives me, and I don't give a shit what
anything else.
What you guys say. Oh,
Well,
you again. What they say.
Yeah, like you getting lumped in.
Defend. Come on, Jason. Let's go.
Well, here's the thing, counselor. How much of the effect, though? You kept saying over and over, print media, television. You didn't mention the 12 Angry Men effect, the Matlock effect, the A Few Good Men effect, the Liar Liar, the My Cousin Vinny. How much burden does Hollywood share in this whole, basically portraying something the way the system works to the jurors and affecting how they then view your arguments?
Here's my answer to that. Those kinds of things, My Cousin Vinny, Perry Mason, the guy that's how old I am, Matlock, whatever. Those are the things that you're talking about when you're telling them that you don't want them to have any preconceived notions. But
Jury selection voir dire is what he's talking about.
No, but I don't worry about them because they're not talking about this case.
Right.
They come to court and they think that we're, basically we're just the shills for the guilty defendant. We can get them out of that. What I'm concerned with is what's going on in the press on this case in this area.
Yeah.
That's a different thing. And I want to make.
We could do a whole other episode.
I think
on
we
that.
should.
We could. Because I can tell you, I do the best I can, and I certainly did it in Wheatley's case, to convince the jurors that everybody in the media is full of shit and they don't give a crap whether they're honest, whether they're accurate or anything like that.
Damn.
I'm going to steal this guy as a guest for my program,
He's
Jason
so
Car
good.
Drive Overdrive. I'm going to have him on.
Fishy's the best.
He's unfiltered.
Really?
No, he's never been accused of that before. All right. Well,
We're done?
ladies and gentlemen, Gloves Off Podcast, episode 28. Thanks for joining us. This was amazing. Jason, Steve, as always, thank you. And I know, I read what you say. Yes, we should do this more, but, and maybe we will. Fish.
One other thing.
Yes, sir.
Hail to the victors.
Oh, here we go.
That's it.
Jason, anything?
This guy. Congratulations on your eventual national championship, being that we're recording this before it happens.
Let's hope
there you
so.
go.
All right. Signing off. See y'all. Go Fighters.